Good evening, viewers and listeners. Welcome to this special edition of Serving the People, brought to you by the Democratic Republican Party of St. Vincent and the Grenadines, the DRP. I am your host, Mrs. Anissa Batiste. Please let us start as usual with a word of prayer. O loving Father in heaven, bless me as I speak the truth and nothing but the truth to the people, and may they understand clearly what I'm explaining, that they may assert and defend the protection of their rights and freedoms under God. In Jesus' name, amen. And now, dear viewers and listeners, it's been quite a while since I've addressed you via this program, but I am happy for the opportunity to do so once again. It is urgent. I come before you to explain to you certain dangerous anti-free speech provisions within the Cybercrime Bill 2016, which is currently before our Parliament. Yes, I need to show you how certain things in this bill are against our constitutionally guaranteed freedom of expression and moreover our inalienable or God-given freedom of expression, which takes in freedom of speech, freedom of the press, freedom of information, the right to know, and the other private domain freedoms of our minds, which we use those public freedoms to express, such as our freedom of conscience, our freedom of opinion, freedom of thought, freedom of belief, freedom of choice. Fellow Vincentians, I was invited to sit with the select committee as they met on this bill. As we reviewed the bill, I saw certain dangers in it for free speech, and I expressed repeatedly why certain things needed to go from the bill or to be reformed in cases where reformation can take place to ensure that people's right to freedom of expression is not infringed upon. Unfortunately, select committee meetings came to an end still having certain dangerous provisions in the bill. So even the revised bill that you will see published in the newspaper or the revised portions of the bill, I want to talk to you about how they are still dangerous to our free speech. I want to warn you, when government is passing law in the Parliament, they talk about it and they talk about how nice the bill is. But just like in the days of the referendum in 2009, the Constitution had some good things, yes, but it also had some very bad things for the rights and freedoms of the people. And none of us have to accept the entire thing just because there are good things when there are bad things that will infringe upon our rights and our freedoms. So I want to talk to you about that. The first thing I want to defend is my position when I came out and spoke in a letter to the Reporters Without Borders, RSF, an international freedom of the press, freedom of expression watchdog organization, and I spoke to them about my concern about the process involved in bringing this bill to the people and its review. And I want to maintain that this is dangerous, the way we went about with this bill. Here's why I say this. First of all, the bill was only published in the newspaper about June 10th. And when it was published, at least on that occasion, June 10th, opportunity was given for people to submit opinions by June 13th. So it was published on Friday and you only had 2 days over the weekend to submit your opinions on the Monday. I raised concern that this was too short a time. Few submissions were made. I believe that people did not have the proper opportunity to study the bill because one, the bill was introduced into the Parliament at the end of May, the 31st of May to be exact, of this year, and the whole month of June and July for the most part of it, as you all know, was carnival. So by the time this bill was published, many people are not paying attention to this long legal explanation of a bill in the paper because they are caught up with the carnival activities and so on. It was not the right time to introduce this to the people if you really sincerely want them to study it and to know what is going on. Secondly, there were no meetings, no explanations of the bill to the general public, no town halls, no meetings with different aspects of society, let's say media houses, etc. By the Ministry of Information, for example, they failed to inform the public about the bill. So I'm not satisfied about just publishing it in the paper during carnival time when many people weren't paying attention. In addition to that, in context of that, you had a select committee where persons were invited to make contributions. But when you look at the kinds of people who were invited, you see where there was lack. You see, for example, there was no invitation from media. There was no invitation, to media houses. There were no invitation, there were no persons represented in those meetings of select committee, let us say from young people organizations, from people who use broadcasting like preachers, religious preachers, and other persons who are using online to broadcast their messages so they will understand how cybercrimes legislation will affect them. There was no representation from the Human Rights Association. There was no representation from other groups and other persons in society that could be easily affected and that could have an objective view to what is going on. The majority of the representation was from agencies that, while some of them are NGO, non-governmental, yet they were represented by persons, and in at least one case, a person who holds a political party executive position with the ULP. And of course you have the ULP persons who were there because they are members of the committee by appointment by the Prime Minister, but they also hold high position in the party. So they are not going to go against the Prime Minister's bill that he introduced. And that is what happened in the Select Committee. I'm not lying about that. There are positions that I will explain to you today where I can tell you, for example, in one case, no other person could have defended or even opened their mouth to defend the Prime Minister's position on the criminalization of libel. I am satisfied that what I said to Reporters Without Borders about the concern about conflict of interest on that select committee is true. Because when you have a lot of political party members and holding high position of the party, and persons also who are related to the Prime Minister sitting there, it doesn't give the public much comfort that there will be objective assessment of the bill, and that if you have to oppose the Prime Minister vehemently, you will do so in the interest of the protection of the rights and freedoms of the people. I was the one who was primarily doing that in those meetings. Having said that, let us look at some of the aspects of the bill, because I know we wouldn't have much time. Let's look at some aspects of the bill which are dangerous to free speech. Now, there is a provision criminalizing something called cyberbullying. They're saying basically that if you use the internet on any of your devices, your phone, your iPad, your laptop, and you use anything on the internet, whether it is a website, Facebook, Twitter, WhatsApp, any program using the computer system, if you use it to cyberbully a person intentionally or recklessly, you would be guilty of a crime. But what does cyberbullying mean? Now, what they have done is that they have separated this into two parts. No, they're now saying that they're creating an offense for the cyberbullying of children and vulnerable, which means persons who have physical or mental disability. And then you'll have a separate provision for the cyberbullying of persons who are not children and vulnerable. In other words, adults who are not vulnerable. This provision defines cyberbullying in a certain way, which is dangerous to free speech, and I'll explain why. It says, and I quote, "A person who intentionally or recklessly uses a computer system repeatedly or continuously to distribute or transmit any information, statement, or image, A, that causes a person other than a child or vulnerable person to feel frightened, intimidated, or distressed, and that causes harm to the person's health or reputation, commits an offense." So if you publish something on the internet that causes an adult person who's not disabled to feel frightened, intimidated, or distressed, and causes harm to the person's health or reputation, you commit an offense. Now, the maximum you could face on summary conviction is up to $100,000 or to imprisonment for 2 years. This is if you cyberbully an adult who is not a disabled. Now, my point is this, and I want to say to you, the definition for cyberbullying of children is similar in that it says the same thing basically, but it says, instead of saying and, it says or. So, for example, if you cause the child or the vulnerable to feel frightened, intimidated, distressed, or humiliated, or if you cause harm to the health or reputation of the child or vulnerable person. So either or, if you do any one of them, you're guilty of cyberbullying. And also what is different here is the penalties, because in the case of cyberbullying of a child or a disabled, you will pay more money, or you can go to jail for a longer period. You can go to jail for up to 3 years on summary conviction, or you can pay $150,000 maximum on summary conviction. And in the case of on conviction on indictment, you can go to jail for up to 5 years, or you can pay up to $250,000 in fines, or both. I have to add that. It's either fine, jail, or both. In both cases, whether you're cyberbullying an adult who's not a disabled, or you're cyberbullying a child. Now, there's several problems I have with this, and I'll explain why. First of all, the vague language used to describe the ingredients of the offense. You're saying to me that if a person publishes something on Facebook and another person says they feel intimidated by it, they feel distressed by it, what is that? What does distress or intimidated mean? A person could be distressed over the simplest thing that you post on Facebook. They can be distressed over the truth that you say, because the truth offends. And if you do it repeatedly and they say that they are distressed, okay, and they somehow find a way to bring some paper from a doctor to say it caused their health harm. For example, the blood pressure raised up and has been high for the last 3 weeks because of this thing that you are saying on Facebook. Even though the thing is true, they can bring an argument. Now listen, don't tell me leave it to when it gets to the courts for evidence, because the fact is you're encouraging people to bring things based on how they say they feel and based on whatever they could produce as so-called evidence to claim that it did harm to their health. You're encouraging people to flock the police stations and complain over things that people say that are true. And I am saying this is not right, because you have to have freedom to speak the truth, even when it offends. The truth offends. The Bible says that Jesus Christ, preaching Jesus Christ to the Jews, for example, he was a rock of offense. Should the disciples be punished with criminal charges because they preached the truth that caused some people offense, that caused some people to feel distressed? We cannot pass law like that. The language is too vague. What do I mean by vague anyway? When we say that the language is vague and subjective and lacks legal certainty, we are saying, and I want to refer to at least a quotation from a judgment. This judgment was in a case called Connolly and General Construction Company, and it was from 1926, and the judge said this, and I quote, "A statute is vague and therefore facially invalid if persons of common intelligence must necessarily guess at its meaning." End of quote. When people read this law and they see that if I publish something on Facebook that a person says they're distressed by, I could be criminalized. This is vague. A person has to guess what is distress, what is causing distress. What person A might find distressful, person B may not find distressful, even though it is the same information being published. So therefore, one person could be caught under the law, and another person could go free for publishing the same exact things, just because one person reacts this way to person's A statement, and another person decides ignore that, walk away, or just answer back the person and forgets about it. This does not create equality under the law, and it could lead to discrimination against persons. A person could have a vendetta. They may be lying. They may want to get at you for some revenge and say, well, what you published caused me distress. This language is not fitting. It is incompetence in drafting. It is a poorly drafted section, and I'm not saying the country is responsible for it because it was handed to us. But since Select Committee met and refused to deal with the vagueness in the language, then they're responsible for the incompetence and poorness in drafting. And my dear people, this is bad, because what you do, you will capture a set of expressions which are legitimate under these things. And I want to quote to you in this case from a judgment that was passed just last year in Nova Scotia in Canada. Yes, my dear people, in Nova Scotia in Canada, a certain judge called Justice Glenn McDougall, he struck down an entire Cyber Safety Act of 2013, and this judgment was given in December 2015. And in looking at the language used to define cyberbullying in the Nova Scotia Act, the language was very similar to ours. It talked about if you intended to cause fear, intimidation, humiliation, distress, or other damage or harm to another person's health, emotional well-being, self-esteem, or reputation. Now, our law too speaks about intent, because it says if you intentionally publish something that causes, okay? Now, the cause depends on the person. The person will say, I felt this way. What you said caused me to feel this way. You may speak the truth and you do intend for the truth to be spoken. And yes, a person may say they are distressed. You can't say you didn't intend to cause distress, because the fact is, sometimes you have to speak the truth whether or not people are offended. That is our duty as Christians, for example. That is our duty as people who have to put matters right and clear in a society where error takes place. You have to speak the truth. And even if people are offended, you just have to. What did the judge say about this language in the Cyber Safety Act of Nova Scotia? And I'm mindful of my time. He said, and I quote, "I need to consider all the types of expression that may be caught in the net of the Cyber Safety Act and determine whether the act unnecessarily catches material that has little or nothing to do with the prevention of cyberbullying. In this regard, the Cyber Safety Act and the definition of cyberbullying in particular is a colossal failure." End of quote. Here is the judge saying, look, when I'm judging the definition of cyberbullying, I have to consider whether it catches material that has little or nothing to do with the prevention of cyberbullying. In other words, if you're going to define what it is to cyberbully and you're going to be prepared to put people in jail for it, you're talking about speech online. You have to be able to see if you're going to catch speech in the definition which is not cyberbullying. Is it cyberbullying to speak the truth? It is a criminal offense now to speak the truth because somebody says they're distressed by it, because somebody claims they suffered harm to their health by it. Should Jesus have gone to jail and pay fines because he called the Pharisees and scribes generation of vipers and hypocrites and children of the devil? Because that is the truth about what they were, and that's his opinion, that's the truth. Should he have been criminalized for that if he was using that on the internet today in 2016? These are the things you need to think about, my dear people. And I am saying to the Select Committee, to the Prime Minister, to this government, you cannot pass laws so vague that it cannot direct people as to what exactly is criminal, so that you restrict their speech because they are afraid to speak now. Even if they're speaking the truth, they're afraid because they know it's possible they could go to jail for even the truth. Once somebody could say they are distressed about it, and once they could bring something to say that it harmed their health. And now, mind you, even if it never reached the courts, you're going to have the police stations bombarded with vendetta arguments and complaints, okay, with a lot of thin-skinned persons who don't want to deal with the fact that they need to be tolerant and that everybody's not going to say what you want them to say. And you have to respect that that could happen. And this is not good. We are making our society thin-skinned by passing such things into law. But furthermore, have you observed that in an effort to claim that they are protecting children by making the cyberbullying offense against children and vulnerable or disabled have higher penalties, do you know what they've done by that? This is what they've done. This is a fact. Children also cyberbully children online. So your child may go online and say things about another child that the other child feels hurt about, that the other child feels distressed about. What you have done there by raising the penalties for the cyberbullying of children is that you will potentially capture children with higher penalties, okay, than even adults will have to face if they cyberbully another adult. Because the penalty for cyberbullying a child is greater. You pay more money, the maximum, and you could go to jail for a longer time, the maximum. So the point is, since a child could cyberbully a child, then I mean a child now faces a maximum of $150,000 in penalty, in fine, or jail time of 2 years, or both, or if the child is charged on conviction and indictment, they face a maximum of $250,000 or 5 years or both. That is more than the maximum than the adult faces if the adult cyberbullies an adult. And tell me you're protecting children? You see, they don't think. They only want to make an argument, an emotional argument about children, when in truth and in fact, this does not protect children. Because if you really want to help children who have a problem with cyberbullying each other, you should do like other countries have done and have rehabilitation programs to teach children how to use the internet responsibly. Interact with parents. Let the schools administrations have policies where if a child is found in that activity, their device can be taken away, the information can be taken down from the internet with cooperation with the telecommunications providers and so on, and you can actually have counseling for the child, to teach him to be rehabilitated from his bullying ways, and even to teach the children who are the victims to become victim proof, how to deal with them, how to delete stuff, how to block, how to ignore, how not to have certain kinds of friends who engage in that, and so on. But this is not the case in this bill. There's no encouragement of that sort of rehabilitation methods like the Trinidad bill provides. In fact, there's nothing in here that will not criminalize our children. And I want to know where you're going to put those children in jail who cyberbully if they are caught under this law. Where are you going to put them when we have no juvenile detention center, okay, here in St. Vincent and the Grenadines? These are the kind of things you need to think about. But children can be criminalized under this section of cyberbullying, and the truth itself that you speak can be criminalized. Preachers can be criminalized for telling sodomites or homosexuals that they are in sin, that their behavior is abominable, that they will burn in hell fires because God says he will burn them with fire, and he will burn people with fire for sin. And if you call out a certain person's name, for example, in high society or whatever, and you show them that, and you repeatedly show that in your programs or whatever, they could say that you're distressing them. They could say that you're causing harm to their health because they can't take being rebuked over and over about their sins. These are the things that could happen. And this is very bad. But this happens because of the vagueness, the subjectivity of the language. And when the language is so unclear, lacking legal certainty, you leave it up to the law enforcement people, the police, the prosecution, the magistrates, the judges, who are just human beings, who can make mistakes, who can be biased and influenced by political persuasions and other things. You leave it up to them to interpret because the law is so vague. And so there's opportunity for arbitrary interpretation and application of the law, which could lead to discrimination against some persons. This is unacceptable. Now, in the little time we have left, I want to at least be able to address another point that is very bad for free expression in this bill. And it has to do with libel, criminalizing libel. Libel, my dear people, has to do with when you publish in some permanent form a lie against a person. And that is bad and it is wrong. And we already have in our civil laws dealing with defamation, we already have a redress for people who have been lied about. Lies have been published against you. You can go to the civil court. You can sue a man for money, okay, for damages. You can get compensation for the lies that he has told. What the Prime Minister is doing with this bill, with the libel by electronic means section in this bill, is he is seeking to revive something called criminal libel or criminal defamation that has been in our books for a very long time but has not been used. He himself has admitted that in his lifetime he cannot remember it being used, and he's about 70 years old. And I'm saying what has happened over the years is that many organizations, international free speech bodies like Reporters Without Borders, Center for Law and Democracy, like International Press Institute, like Committee on Protection of Journalists, like the OAS Special Rapporteur on Human Rights, like the United Nations Human Rights Committee, under the International Covenant of Civil and Political Human Rights, Article 19. All of these bodies and others have shown that criminal defamation, sending a man to prison, giving him a criminal record for a lie he published, is extreme. What they're saying is this: punish him, yes, but punish him in a civil court where he have to pay monies as compensation to the person he has lied about. And even if you want to claim that, what about a man who doesn't have money to pay? Well, you can have the court order that he publishes an apology in the same place where he published the lie. For example, in the newspaper or on the Facebook page. Publish an apology by court order showing that he was guilty of defaming you, and the same way he published the lie, the published apology will correct the damage done by the lie that he told. Also, you can have him do community service if he repeats the lie, or other measures that would clearly show that he's a liar, and nobody's going to take what he says seriously anyway. Because if you have no money to pay and you just keep lying on people, then obviously you're just doing it deliberately and you're not to be taken seriously. These things can be done. But instead, the Prime Minister of this country wants to jail people for speech, as if nobody for him ever tell any lie on anybody. And when I say that his supporters, I mean, I know I've been lied about by them, but I've not even called for them to go to jail. We need a tolerant society. It is true, people shouldn't lie and they should be punished. But the punishment must be proportionate to the wrong. Remember, this person hasn't lifted a hand to stab anybody. They haven't raped, they haven't murdered, they haven't shed blood. They have told a lie with words, and lies told with words on the internet are bad. Punish it, with penalties in a civil court, not by putting the person in jail. Because what that does is it has a chilling effect on free speech. It has a chilling effect on the freedom of information and the press by journalists who have to do their work and who may now be afraid to work with sources and to give information about corruption because they are fearful that some official will come up and say, oh, you lied somehow, and maybe they have a source they want to keep confidential, so they can't use the defense of truth in the court, because if they do that, they will have to reveal their source, and because of that, they may take the rap and take the defamation conviction. But it may not necessarily be because what they said was a lie, but because they couldn't prove it. So you see, when you put imprisonment as a punishment for defamation, what you will do eventually is cause freedom of speech, freedom of expression to be chilled. People will be afraid and will be pushed into self-censorship where they are free to talk. And this is not good in a democratic society where you need to feel confident and free to speak the truth, to expose wrongs. All these agencies I've called have condemned it. This has nothing to do with me or the NDP jumping on some bandwagon. The point is, if we are foolish, then you're saying these agencies are foolish as well. We inherited criminal libel from the UK, from Britain as a colony. It's been on our books for a long time. Why are we keeping a backward, archaic law like that when the very UK has decriminalized libel since 2009? You pass a law the other day and say, let us move the law saying we have to swear an oath to the Queen, her heirs and successors, because it's backward, we're moving forward. But yet, you want to keep a backward provision of criminal libel on the law because you want to use it against your opponents to persecute them by putting them in jail. This is what a government could do if such a thing is revived in the society. And I'm warning you, Vincentian, sometimes people talk. Because they're bringing the bill, they want you to accept it, so they talk and they give you the nice parts. But understand this, you never know the hidden agenda until the law is passed. You never know what is behind there until the law is passed. But when the law is passed, the hidden agenda will manifest itself. Already we have people talking about keeping criminal libel there to deal with so-called statements they claim the opposition leader made against them. He could go to jail according to criminal libel. My dear people, I am warning you, do not accept the anti-free speech sections in this bill. My time is up. I don't even have enough time to show you the other things that are dangerous. But I'm warning you, don't allow your eyes to be blinded by the blind leaders. Don't become a blind follower of blind leaders who want to trick you into thinking that these parts are good when they are not. This has to do with personal vendetta, personal revenge to get back at people for things said on Facebook, etc. And by the way, I don't support any threats to people's lives. None at all. But the point is, do not criminalize speech that is not threats. Do not criminalize speech that is truth. Do not criminalize our children and youth who could be caught in speaking the truth in cyberbullying. Let our society learn to be more tolerant. Let us learn to just ignore things, overcome them, walk away, or answer back with your own criticisms. But to send people to jail for speech that is not harmful, that is not illegal, that is against God, because you're limiting people's freedom of speech, which God himself gave to them. And you as government, you as human beings, mere human, puny beings, puny meaning weak, in context to God, you have no right in the face of the great God, as small human beings that you are, to pass laws that will limit his people's freedom of speech, when he himself, when he was on earth in the form of Jesus Christ, never asked any government to lock up anybody, even though they said the most evil things against Jesus Christ himself in the earth. Know your place, O you government. And my dear people, pay attention. I'll bring more education to you very soon. God bless you. Call me 528-1015. Bye-bye.